So in this video, I briefly want to talk about what is a patent attorney because a lot of people don't understand the difference between an attorney versus a patent attorney. And there are very important differences. So a patent attorney, first of all, has to be an attorney. Whether you're an attorney or not, is an issue of licensing from the state. So the state that you reside in, of course, attorneys can be licensed in multiple states, but generally the state in which an attorney resides will usually be the state in which they obtained a license to practice law. So in order to obtain a license to practice law in a state, you have to pass a bar exam and meet another series of qualifications. You have to pass certain background checks that are imposed by that state regulation. And once you go through that process, you can become an attorney licensed to practice law in the state. But that's for general law. Now, patent law is a particularly esoteric area, and so patent attorneys are registered with the United States Patent and Trademark Office. So if you're an attorney, you can't practice patent law before the United States Patent and Trademark Office unless you meet the United States Patent and Trademark Office USPTO requirements. So those requirements are that you take a special bar exam, which we affectionately refer to as the patent bar. So not only do you have to take the bar exam of your state and become an attorney, but you have to take a second bar exam from the USPTO called the patent bar, and you have to pass that. And the patent bar has a very, very low pass rate. It's changed over the years, but traditionally, takers of the patent bar, it's usually about a 20% pass rate. So it's a very demanding exam. And you also have to have a technical background before you can even sit for that exam. So generally, you have to be an engineer or a scientist. You have to have some sort of a hard science background. And if you're not an engineer or scientist, you can get in on under other technical qualifications, provided that you take a certain number of courses in physics and things like that, so that you can meet the USPTO requirements. To call yourself a patent attorney, you have to be, number one, registered as an attorney in the highest bar of some state within the United States. And two, you have to have passed the USPTO patent bar exam and be a registered patent attorney with the USPTO. Now, there is another type of person that can practice patent law before the USPTO, and they are referred to as a patent agent. So what is a patent agent? I actually became a patent agent before I became a patent attorney. How did I do that? So if you take the USPTO patent bar exam before you become an attorney in a state, you will get the title if you pass the exam and you meet the other background check and other qualification requirements, for example, having the correct technical background to sit for the exam and so forth. The USPTO will give you a registration as a patent agent. So as a patent agent, you can practice only with respect to patent prosecution. So you can prepare a patent application, file the patent application with the USPTO, and then perform what's called prosecution, which is arguing the claims of that patent application until the end, which is either the patent gets granted, the patent application gets granted as an issued patent, or the rejections are too strong and the applicant decides to not go forward anymore and the application becomes abandoned and never becomes a patent. So that's the limitation of what you can do as a patent agent. You cannot do trademark law because trademark law, in order to do trademark law, you have to be a registered attorney in a state. A USPTO patent agent cannot do trademark work. They can't go into court and argue in litigation. They can't do contract work. So those are the distinguishing features. And that's what makes a patent attorney a patent attorney.